everyone. Welcome to the Legal Tea Podcast. I'm your host, Elena Clarkson, and today I have with me attorney Alexis Wilson. But before we get started, Attorney Wilson, please introduce yourself.
Hi, everyone. My name is attorney Alexis Wilson. I attended Southern University Law Center. I graduated from the Law Center in May of 2023. I took the bar exam in July of 2023 of that year. I passed the bar exam on my first try. Upon passing the bar exam, I worked as a prosecutor for a couple of years, and then now I'm working as a public defender. But before I did all of that, before I even went to law school, I worked as a city clerk in the clerk of court office for 6.5 years. So I've been around the process. I've been in the process. I've participated in the process. I have a lot of legal knowledge, a lot of legal experience. So I'm here to share the legal knowledge and experience with the world.
Thank you. Clearly, she is an experienced attorney. So now let's get started talking about small claims. Attorney Wilson, what exactly is a small claim?
So a small claim is a civil suit that is filed for usually a smaller sum of money. That's why it's called small claims. There's a couple of ways you can file it. You can file it in different courts. In Louisiana, usually there are district courts. There are city courts also. There's justice of the peace courts. There's federal courts. But usually, if you're filing a small claim suit, it's going to be either filed in city court or it's going to be filed in district court. How you pick the court is city courts are capped at a certain amount. Most city courts are capped at like $30,000, but there is a civil code article that you can Google that defines the amount cap that all the city courts have for the civil suits that they can hear. So if you're living in the area, living in a city with a city court, either you can call that city court, the clerk of court office, and they can tell you how much is their cap, or you can seek out that civil code article and it can tell you how much the cap is. Usually district courts, they usually don't have a cap on the amount they can hear. But if you want more information, you can just call the clerk of court office for that district court and they can be able to explain to you what the cap amount is or if there is a cap amount.
All right. Now, what exactly does a person need to bring to prove their case, to file their case?
Okay, so if you have set and you figured out that someone owes you money, or that you did a job for someone and they didn't pay you, or somebody, I don't know, wronged you in any kind of way and they owe you money to make you whole. After you determine that, at that point, you would need to gather any written document, any pictures, any proof that will prove your case, that would help the judge determine that you are entitled to this judgment that you're seeking. Once you gather all that information, it could be letters, it could be text messages, it could be emails, it could be contracts. Speaking of contracts, if someone come to you and they're like, oh, I need to borrow a couple $100 until this date, please always put that in writing, because there are statute of limitations on certain things that you can file. Like, you don't have an infinite amount of years to file a small claim suit. And if you put it in a written contract, you have 10 years to file that. So, that gives you a lot of time to, ask them for the money. And if they don't give it to you, you have a lot of time to file that and get that done. If you don't do that, then you might run the risk of not being able to prove your case effectively. Even though Louisiana do honor oral contracts, you would probably need another witness, another body, another person to come in and testify saying that they heard that other person say they would give you this amount or do this thing for you, to help prove your case.
Now, when a person is ready to file their claim, how do they know what court to choose from?
So, okay, once you have said and you gathered all the information, you gathered all your evidence, what you're going to do is you're going to sit down and create a breakdown. Once you create that breakdown, you're going to see the total amount that you're seeking. If you are over that cap amount in that city court, like for instance, if the cap amount is $30,000 and you sit down and you go through everything, and when you get to your total is $35,000, then you would need to file that suit in district court. But if you get to it and you total settle everything and you're like $29,999, which is under, you can file that suit in city court. Just be aware that city courts do not offer jury trials. If you are seeking a jury trial, you would need to file that in district court. Also, there are certain suits that cannot be filed in city court. I implore you to Google that. It will be able to give you that information on what can be filed in district court, what can be filed in civil court, small claims, city court. But once you have determined the amount that you're seeking, you can file either in district court or city court. Just a note. City courts are usually smaller, so you'll probably be able to get a court date and get on the docket faster. In city court than it would be in district court. So once you make your determination of how much you're seeking, that really determines which court that you file it in.
Okay, so when one is 100% ready to go to courts, are they allowed to represent themselves or do they have to get an attorney?
So actually, you are allowed to file your petition pro se, which is self-representation. Actually, it would cost a lot less money to file it yourself. Rather than hire an attorney. The only time here's the thing, you can seek out an attorney to help you and guide you in the process. However, to hire an attorney for a civil suit, I suggest that you sit down and weigh that option. If you're suing somebody that have the means to pay the money that you're suing them for, then you might want to seek out an attorney. Okay? If for a fact they don't have the money to pay you back and you don't have the money to pay the filing fees to file this petition, you might want to do it pro se. You might want to sit down and weigh the financial burden of doing that. Also, filing a civil small claim suit isn't free. There are filing fees associated with that. You can call your local clerk of court office in district court or in city court, and they can let you know what those filing fees are. If it's a situation where you do not have the money for the filing fees, that doesn't mean that you cannot file your suit at that time. There is a thing called informal pauper status, which means you will file a sworn affidavit saying that you're indigent or that you lack the financial capability to pay the filing fees up front. You will fill out that affidavit. You will turn that in with when you file your petition. Ultimately, the determination is made by a judge if you qualify for the informal pauper status. Once the judge made that determination, if you do qualify, then you're allowed to proceed with your small claim suit, and the fees doesn't disappear. They're just not due up front. They're due at a certain time, but it's later in the process. But if you do not qualify for informal pauper status, there are a plethora of different places that can offer help, financial help and assistance that can help you get the money to file that civil suit. I implore you to use Google to find out and seek out those resources here in the state of Louisiana.
I noticed that in the beginning you used the word petition. Can you exactly explain what a petition is and what it must contain?
Okay, so the petition is actually the formal paperwork that states who you're suing, why you're suing, and what you're suing for. In the state of Louisiana, a petition must contain your information, which is the plaintiff. You're the plaintiff. And what I mean by your information is your address, your phone number, email, any way that the court can contact you. You will also need that same amount of information for the defendant, the person that you're suing. You're going to need an address. You're going to probably need a phone number. You're going to probably need an email address for them also. If you're not able to find an email address or a phone number, you definitely need a physical address because they're going to be served with a copy of your petition. Also, the petition is going to need the cause, the reason why you're suing, which is a factual basis based in fact of what took place and why do you believe that you're owed the money or whatever you're seeking to be made whole. Also, it's going to need a prayer for judgment clause. In the state of Louisiana, usually you do not put a sum of money in the petition. It just really depends. Some courts, if they have, a lot of city courts have their petitions pre-printed where you can just go to the city court and it will have blanks for you to just fill in. And if they ask for a certain amount, you could just write it in. But normally that's not standard practice, but you will seek out an attorney on that. Once you fill out your information for the petition, it must be signed by you. Once you get your petition together and have all the information together, you're going to need a copy of all the evidence that you gathered. So do not give the clerk of court your originals, because you're going to need to present that as evidence when you actually make it to court. So you've given them a copy. You're going to need that petition. If you're claiming informal pauper status, you're going to need that affidavit. If you have no interest in claiming the informal pauper status, you can have the filing fee on ready. You're going to combine all those documents, and then you're going to bring that to your local clerk of court office. Once you bring that to your local clerk of court office, you're going to tell them you're there to file a small claim suit. They're going to collect all the paperwork from you. Then they're going to issue a docket number. A docket number works as your case identification number. There's a lot of, common names. There's a lot of common last names. There's a lot of common, different companies that's been sued multiple times, or different people that have been sued multiple times. But that docket number is the thing that is specific to your case, that the court can locate and find your case and give you updates if you called about it, or when the case finally make it to the docket. That's why it's called a docket number, because that's the number on the docket to identify your case. And that's usually given after you file your paperwork by the clerk of court's office. Some clerks give it as soon as you file the paperwork. They certify it and give you your docket number. Some of them take the paperwork and they do the paperwork on the back end, and they mail you your docket number and an official letter telling you when your court date is. That's why it's necessary to have updated and current information for you and the person that you're suing.
Now, everyone knows in life everything has a cost. If you had to roughly put a number on how much it is to file a claim, what would you say?
It varies. It varies. It literally varies by parish. It varies by city court. It varies by the court itself. There is no city court or district court that actually has the same exact filing fee. I implore you to reach out to your local clerk of court office in the district court or in the city court that you plan to file in, and they will tell you exactly how much you would need to file that small claim suit.
Now, when a person is ready to go to the clerk's office, what materials do they need to bring to fully be ready to be granted to file their claim?
So you're going to bring your petition. You're going to bring that affidavit if you're seeking informal pauper status. You're going to bring copies of your evidence. And you're also going to make sure that you have updated information and anything else that the clerk's office would need. I suggest you call the clerk's office before you just go there. They can tell you exactly what they would need to have to file your case and have your case opened.
Now, lastly, when one is ready to go to court, what exactly can they expect on their court date?
So, court day is it could be nerve-wracking, but at the same time, it just depends on which court you're in. District courts, I find, are way more formal. They're way more formal court setting, opposed to city courts that are more relaxed. Both courts have like dress codes requirements and things like that, but city courts are smaller. So you may be in court with 10 people or something like that, because their dockets are usually smaller than district court, whereas district court you might be in there with 20 people on the docket in a room full of lawyers that you have to stand up and present your case. But once you get to court, usually the judges, either the judge or the clerk, is going to call the docket. When they get to your case, you announce that you're there. You're going to come up. The judge is going to ask you some questions. The judge is going to ask the defendant some questions. If you have any witnesses, any persons that's there to testify on your behalf, the judge is going to ask that. It's going to give you an opportunity to ask your questions to your witness. Just be advised that the defendant also gets to ask your witness questions. It's called cross and direct examination. That's a explanation for a different video. But once you answer all the court's questions, once the defendant answers all the court's questions, at that time the judge usually renders his ruling. Once the judge make a final ruling, you're gonna get a final judgment. When the judge issues his final judgment. It's signed. You can get a certified copy from the clerk's office, and that's in district or city court. The only difference is in city court, if you do not agree with the judge's ruling, you can appeal to the district court because the district court is higher than the city court. If you're in district court and you don't like the judge's ruling, you can appeal to whichever circuit appeals court that court is located in. First Circuit, Third Circuit, all you have to do, Google is your friend. Google it, it'll tell you which circuit court that the area where you're located at is located in, and you can file an appeal there. The appeals court, they would decide if they're going to review it or not, if they're going to change the ruling or not, or they're going to render it to go back to the lower court. But yeah, court day is not. It's once you get over your initial nerves of being in front of a judge and being in front of people, especially if you're pro se representing yourself. I'm speaking specifically to that. Once you get over the initial nerves, you're fine. But if you have hired an attorney, the only thing you're doing is sitting on the side of your attorney. The attorney do all the speaking, the attorney do all the talking, the attorney do all the questioning, the attorney do all the interactions with the court and everything like that. They really do the heavy lifting. The only thing you do is show up at that point. It's the attorney's job to argue your case and make sure all the legal issues has an answer or is resolved. But if you're pro se, it's really for you to learn the necessary laws you would need to defend yourself.
Thank you, Attorney Wilson, for answering our questions. If you have any questions, please comment down below. This is your host, Eleni Clarkston. This is Legal Key Podcast, and hope to see you next week. Thank you.